Thank you, and please be seated. And good morning, everyone. My name is Curry Mingledorf. I'm assigned to preside over this morning's proceedings. We're here for a limited purpose this morning. I do want to note for everyone's benefit that there is, as everyone certainly is aware, considerable interest in what has occurred in our community in the last several days. For that reason, the court has seen fit under Rule 22 of the Uniform Superior Court rules to allow media outlets to record some of these proceedings. However, under those rules, the court has set in place certain limitations, and I just want everyone to know that the media has been informed of that, and I'm confident that they will comply with that. But otherwise, there is to be no filming or recording by any members of the public or any other individual other than those authorized specifically by the court in its signed ruling. Are we ready, counsel, to begin and bring the defendant in?
State's ready, Your Honor.
All right.
Defense is ready.
All right. All right, good morning, sir. Are you Mr. Colt Gray?
Yes, sir.
My name is Curry Mingledorf. I'm assigned to preside over this morning's proceedings. Mr. Gray, I do need to inquire as to whether you're able to read and write the English language.
Yes, sir.
All right. I also want to inform you, I want to ask you, do you understand that you have the right to be represented by an attorney in these proceedings?
Yes, sir.
And you are, in fact, represented today, is that correct?
Yes, sir.
And Mr. Zane Harmon, you're here on behalf of this defendant, is that right?
Yes, Your Honor.
All right. And you understand that you have the right to be continuously represented throughout this proceeding, and if you cannot afford to hire counsel, then this court is obligated under the Constitution to provide counsel for you without cost to you. All right. I am going to inform you of a few other matters, and I'm not going to ask you anything, just inform you. So one is, I want to make sure that you are aware that you have the right to remain silent. You don't have to say anything at all. And it's important to understand that because anything you might say could be used against you at further proceedings associated with your case. I want to inform you of the charges that you currently face. In essence, you are charged with 4 counts of felony murder, as outlined in the state warrants that have been issued against you. I want to make you aware that the maximum penalty for felony murder, so for each count, the maximum penalty is that you could be punishable by death, by imprisonment for life, without parole, or by imprisonment for life, with the possibility of parole. If you have any questions about these charges, then I would urge you to discuss those with your attorney. I would invite you, Mr. Harmon, to inform the court as to whether there's a request for bond at this time.
At this time, Your Honor, there is not a request for bond. We will file the appropriate motions if that becomes necessary.
All right. An indictment by the grand jury for most felony offenses or accusations, you have the right to receive an indictment for these offenses. And I assume Mr. Brad Smith is here on behalf of the DA's office, or he is our district attorney, and he's accompanied by Ms. Patricia Brooks, who is his chief assistant. A preliminary hearing, you'll have the right also to a preliminary hearing, unless you make a bond, which of course at this point there's no bond being requested, or unless you waive such a hearing. You have the right to a speedy and public trial by a judge or a jury. You have the right to confront and cross-examine all witnesses. You have the right to call witnesses on your own behalf and testify in your own defense if you so choose. As you sit here in this courtroom today, under the law, you are presumed innocent. Your refusal to testify at any point in any proceeding will not be used against you in determining whether you are guilty or not guilty. Counsel, let me just inquire as to whether there are any other items that the court should address before we conclude this preliminary hearing.
No, Your Honor.
No, Your Honor.
Well, I do have one piece of information to convey to the court. There was a development yesterday afternoon that makes it necessary for our office to have alternate counsel appointed, and arrangements have already been made in that regard. I've already explained that to Mr. Gray, and alternate counsel will be appointed by the end of the day today.
All right, thank you very much, Ms. Donna C. Graves. All right, then with that, this hearing is concluded, and you may escort this defendant out. All right, with that, I understand that we have another first appearance hearing, and I think that we're going to have a little bit of a recess before we conduct that. Good morning, sir. Are you Mr. Colin Gray? Am I pronouncing your first name correctly? Mr. Gray, my name is Curry Mingledorf. I'm assigned to preside over this morning's proceeding. This is your first appearance hearing. And at this hearing, I'm first going to ask you just a few questions, and then I'm going to advise you of your rights and also let you know about a preliminary hearing that's been scheduled for you. Why don't you just state your name, please? All right, pull the microphone down, please. There you go. All right, and how old are you, Mr. Gray?
54.
And are you able to read and write and understand the English language without
Yes,
any
sir.
difficulty?
Yes, sir.
How far did you go in school?
11th grade GED.
Okay. And I note that you have counsel seated with you at the table. Do you understand that you have the right to be represented by an attorney at all times for this and all future proceedings in your case?
Yes, sir.
And do you understand that, of course, if you cannot afford an attorney, that the public defender will be appointed to represent you upon your request?
Yes, sir.
All right. And counsel, would you identify yourself, please, for the record?
Donna C. Graves, we are going to have new counsel assigned to Mr. Gray later today.
All right. Thank you. All right. Okay. Sorry. Just need to make sure that the system is working. And all right. So the following aren't questions that I'm going to ask. I'm just informing you of some things. You have the right to remain silent. Anything you say can be used against you at further hearings or at a trial on the charges that you're facing. For this hearing, you're not going to be questioned about facts and circumstances surrounding your charges. You are currently charged with, and you'll be provided with copies of the warrants if you don't already have them. You're currently charged with 2 counts of felony murder in the second degree. You're charged with 4 counts of felony involuntary manslaughter. You're charged with 8 counts of felony cruelty to children in the second degree. Now, for these offenses, for the felony murder counts in the second degree, felony murder in the second degree, the maximum penalty for each count is up to 30 years imprisonment. For felony involuntary manslaughter, of course, again, there are 4 counts. The maximum penalty for each of those offenses is 10 years imprisonment. for the 8 felony cruelty to children counts, the maximum penalty under the law for each of those 8 counts is 10 years imprisonment, for a maximum total possible penalty for the charges that you currently are facing of 180 years imprisonment. If you have questions about these charges, which I assume that you will, the court urges you to discuss those with your attorney. Let me inquire as to whether there's a motion for bond, if Mr. Gray is moving for bond at this time.
No, sir, not at this time. We will allow alternate counsel to make that decision.
All right, thank you. All right, I also need to inform you that you have the right to an indictment by a grand jury, and you also have the right to a preliminary hearing unless you make bond or waive such a hearing. You have the right to a speedy and public trial by a judge or jury. You have the right to confront and cross-examine all witnesses. You have the right to call witnesses on your own behalf and testify in your own defense if you so choose. I want to make it clear to you, Mr. Gray, that you are presumed innocent. Your refusal to testify at any point cannot be used against you in determining whether you are guilty or not guilty. I mentioned the first appearance hearing a moment ago. That is being set for you for December 4th, 2024 at 8:30 a.m. Currently that's set to take place in the Magistrate Court of Barrow County. It could be subject to change, but I just want you to know that that is the date that we currently have. In fact, counsel, could you approach, please? I have this, let's see, I need to scratch this out. This document that discusses bond and gives the date of the preliminary hearing, and I guess I could sign that, and then he can just get a copy of it. And then the warrants are attached to that. Sign that. So, and I would like for him to sign it. Turn it over, please.
Sign right there, just so you're getting a copy of this. He is giving you a copy. He's going to give you a copy of all the warrants. Do you want me to go ahead and give him his copy?
Yes, please.
And the page continues. I'll put on the first one. And are these his copies of the warrants?
Those are provided, and they say service copies on them, so I assume that they're for him.
Okay.
Sergeant Briscoe, do you concur with that? Is that what those copies are for?
That's the detention center.
Those are for the detention center? So he's got his own copies, or he'll have them provided? All right, so the detention center wants to hold on to those. All right, let me, and thank you, Ms. Seagraves. I want to certainly acknowledge the presence of our district attorney, Mr. Brad Smith. He's assisted by his chief assistant, Patricia Brooks. Is there anything else, counsel, that the court needs to address that I have neglected to address?
No, Your Honor.
No, sir, not at this time.
All right. I do want to thank those who are in the gallery who have an interest and who have appeared. I appreciate the decorum that has been maintained throughout this proceeding, or both of these proceedings today. And with that, this matter is adjourned.
The attorney who's going to represent you, I think his name is James Rogers. We're going to have that official later today.
As they get ready to have this father, Colin Gray, 54 years old, father of the 14-year-old charged in the shooting at Apalachee High School, leave the courtroom here as he has a final few words with his attorney for the time being. We saw that front row full of victims' family members in the courtroom, and a number of things striking us as we watched this unfold together. One, in a matter of 15 minutes, he sat down in the same seat that his son has been in as he heard the charges against him, as well as he was rocking back and forth in that seat and sniffling, looked like he was crying at times.
Total opposite disposition of his son, who came in with, seemingly a straight face, very calm demeanor here. Dad appeared to be extremely worked up. But we also want to acknowledge that we saw the victims' family members there in the front row as well, many of them wearing dark glasses, holding their head in their hands, and just really going through this emotional time as they saw the father for the first time. Once those charges were read, the judge sort of totaling them up here, those 4 counts of involuntary manslaughter. This is video of Colt in court, as you see, total opposite sort of body demeanor there. Again, going back to the charges for the dad, Colin Gray, those 4 counts of involuntary manslaughter, 2 counts of second-degree murder, and 8 counts of cruelty to children. When you add up each count and the maximum weight that each of those counts could carry if convicted, that came down to a total possible for the father of 180 years in prison for Colin Gray.
And what you're seeing happen in court today is this move towards accountability for parents of those accused in these school shootings. Essentially, these charges mean that prosecutors and investigators believe that this father should have known. They're talking about the involuntary manslaughter would be in reference to allowing his son to possess a weapon. The second-degree felony murder, meaning that a person caused a death that involved cruelty to children regardless of the intent. And we saw this father react when the judge said if you total up the possible maximum sentence, it'd be 180 years. For his son, each of those felony murder charges, if convicted, have the potential of life in prison without parole.
And so just to kind of bring this full circle here, why the father was connected to this whole case in the first place. Just last year, we see dad walking in there from a short time ago. So just last year, there was this site called Discord that they saw threats. The IP addresses came back to the dad. The FBI in Jackson County started to investigate. They said, hey, yes, we have these weapons. My son does not have access to them. But then, according to CNN, reading here, the arrest warrant affidavit alleges that the father provided his son with a firearm with knowledge he was a threat to himself and others. That is according to CNN. And then the dad, Colin Gray, told the investigators he purchased the gun used in the shooting to kill those 4 people at Apalachee High School on Wednesday, purchased this gun as a holiday present for his son in December of 2023, a 14-year-old with an AR-15 style rifle, Cheryl.
And that is the weapon that investigators say that he had inside the school. And we're talking about a shooting that happened less than 2 days ago. It was 10:20 on Wednesday, so we're 47 hours before that happened. And some things that stood out to us as we read the transcript of the interview when, after that FBI tip you were talking about, Aisha, came in, they went to the home, they talked to both the father, Colin, and the son, Colt, who was 13 at the time. And the father, according to the transcript, talked about Colt struggling over his parents' separation, being often picked on at school, and that his teenage son often fired guns, hunted with his father. There was a picture of the son with deer blood on his cheeks, and the father saying, pretty matter-of-factly, according to the transcript, that his son knew the seriousness of weapons, knew what they could do, knew how to use them. And then we fast forward 1 year later, and here a father and son both appearing in the same courtroom, in the same seat, on the same day.
In addition to that, what we understand, another shocking detail here about him being in school, he just enrolled at Apalachee High School 2 weeks ago but had only been to school for 2 days. So this incident transpired on just his second day of school, even though he was enrolled there for a student for 2 weeks prior to this event. And so we continue to follow this story, multiple layers to it. We do expect for both of them to be back in court on December 4th for a preliminary hearing.